today. But for introductions, can I invite the rapporteur, Mr. Omtzigt, for a brief introduction? Thank you. Peter.
Thanks, Chairman. Dear Chair and dear colleagues, it's a pleasure to be back in this committee. In October 2023, the Assembly adopted Resolution 2513 on Pegasus and similar spyware and secret state surveillance, based on a report I prepared. In the resolution, the Assembly stated that there was mounting evidence that Pegasus and similar spyware had been used illegally or for legitimate purposes by several member states, actually quite a few, including against journalists, against political opponents, against human rights defenders, and against lawyers. On the basis of this evidence, the Assembly urged the member states concerned, that is Poland, Hungary, Greece, Azerbaijan, and Spain, to inform the Assembly and the Venice Commission about the use of Pegasus and similar spyware within 3 months. It also urged them to conduct effective and independent investigations into all confirmed and alleged cases of abuse and spyware, and provide sufficient redress to targeted victims of unlawful surveillance. The Assembly further called on other member states which appeared to have acquired the use Pegasus, including Germany, Belgium, Luxembourg, and my own country, the Netherlands, to clarify the framework of its use and the applicable oversight mechanisms. It also invited them to send this information to the Assembly and the Venice Commission within 3 months. The resolution proposed that all member states should refrain from using the spyware pending the assessment of the legislative framework by the Venice Commission, and that in the midterm they should limit its use to exceptional situations as a measure of last resort, to prevent or investigate a specific act amounting to a genuine and serious threat to national security or a specific and precisely defined serious crime. Finally, the Assembly called on 2 other states, Israel and Morocco, which respectively enjoy observer and partner for democracy status within the Assembly, to take specific measures and provide information on the use of Pegasus or its export control system. I would like to thank all those member states which replied to our questions. I will analyze all these replies in the follow-up report that I'm preparing for the committee. However, I regret that 2 member states, Belgium and Hungary, as well as Israel and Morocco, have not replied at all to the Assembly and have completely ignored our request. I'm planning to write to them again before finalizing my follow-up report, and I would like to remind them that this was a request not only from me as rapporteur, but from the entire Parliamentary Assembly. And to the other countries, I would add, I haven't forgotten the answers I got earlier. There seemed to be some conflicts in earlier answers and later answers. In order to finalize this report, I decided to organize this meeting with experts and persons who have been targeted by spyware.
Okay.
Thanks. There is some spyware going on. First, we will hear from Iain Cameron, who is online, I see, one of the members of the Venice Commission, who prepared the excellent report that the Assembly requested on a rule of law and human rights compliant regulation of spyware, and I recommend you read it. I would like to thank the Venice Commission for their dedication and detail in preparing this report, which contains interesting guidelines and recommendations that will feed into my follow-up report. Our second speaker is Andreu from the Eynde, a Spanish lawyer who, according to the Catalan Gate report published in 2022 by the University of Toronto Citizens Lab, was infected with Pegasus in May 2020. At the time when he was targeted, he was the lawyer of some of the most prominent Catalan pro-independence politicians who were imprisoned for organizing the referendum and Declaration of Independence in 2017, including the former Vice President of Catalonia, Oriol Junqueras. I hope I get that right. He has filed a criminal complaint before Spanish courts against 2 of the NSO founders, Omri Lavi and Shulaf Uliol, and 1 executive, Yuval Somek. The original complaint also named 2 Luxembourg affiliates of NSO, OZ Technologies and Q Cyber Technologies. NSO, as you know, is the Israeli company that developed and marketed Pegasus. Mr. van der Eynde himself is a lawyer specializing in cybersecurity. Our third and fourth guests come from Serbia. Dušan Pokuševski from the Belgrade Center of Human Rights, and Milena Berić, Executive Director of the association KROKODIL. Our 2023 report tangentially mentioned Serbia, saying that it had reportedly been a client of some companies selling spyware. But more recently, in 2024, there have been revelations about the surveillance of Serbian journalists and activities. According to the Amnesty International report, numerous individuals have had their phones hacked with spyware while in custody, using a previously unknown form of spyware called Novi Spy. The PACE co-rapporteur for the monitoring of Serbia, Axel Schäfer, has already condemned this practice and asked Serbian authorities to stop it and to provide remedies to victims of unlawful surveillance. I'm very thankful for our four speakers for having accepted my invitation to appear before the committee. I look forward to hearing from them, Chairman.
Thank you, Peter. Apologize. Thank you for that introduction. I would like to welcome the four experts, three of which we have with us in committee, and Mr. Iain Cameron that we have online. And can I indicate that we would invite Mr. Cameron and Mr. van den Eynde to address us for up to 15 minutes, and thereafter the other two experts to address us each for a further 7 minutes, but don't feel bound to those timescales. We're more interested in what you have to say rather than the time it takes you to say it. But Mr. Cameron, could I begin by inviting you to address us? Thank you.
Thank you very much, and thank you for this opportunity to make a short presentation. I hope you can all hear me. The thing I'm presenting is the Venice Commission report on rule of law compliant spyware, which was adopted at the Venice Commission plenary session last December. And is available via the Venice Commission website. And of course, it was adopted in response to a request from you. And behind it is both a resolution and a recommendation of the Legal Affairs Committee. Now that work that you've done already goes into some detail concerning the dangers of spyware. So I won't say a great deal about that. I think you're well informed about that already. What I'll try to deal with in the short time I have is the other issues that we raised in our report. But very briefly, I should say something about spyware and the reason why there is such a division between those police and members of intelligence agencies who insist on its necessity, and those who have a totally different worldview and regard it as too great an intrusion into privacy and other rights. The reason for the use of spyware, or what the police and the security services call the more neutral computer network exploitation, is because the internet is constructed in a totally different way from the normal method of telecommunication, the more traditional method of telecommunication. Because communication works differently in the internet, the telecommunication providers, which are national providers, do not, or rather cannot, access the content of messages which travel via the internet. They carry these messages on their networks, but they cannot access the content of these messages. And that means that the instruments or devices which have been, which all member states of the Council of Europe have insisted that their national telecom providers make available, that is the possibility to have a lawful interception of communications going through these national exchanges. These do not work, quite simply, in relation to communication that goes via the internet. And as we now know, that this is ubiquitous now. We use the internet probably a great deal more than we use the traditional telecommunications networks. Now, data that goes via the internet is encrypted. And it is primarily, if you read official reports and the reports of oversight bodies, this is primarily what spyware is used for in both democratic and non-democratic countries. It's to break the encryption. That's the main function and practice of spyware. So bear that in mind. Another consequence, which we don't really think about, of this, the ubiquity of global connectivity and communication via the internet, is the fact that previously the only people who could tap your phone was your own government, basically, or if it was an international call, the government of the country that you were calling to. It was only these actors that had the possibility of monitoring your communications. The fact that we now have global communication technology means that these communications can be monitored from anywhere in the world. We can make the communications to anywhere in the world, but it can also be surveilled unlawfully by actors anywhere in the world, including, as we heard in the introduction, including non-state actors, companies, which have made it a speciality to sell this spyware technology to the highest bidder. What is special about computer network exploitation, spyware, is that it involves the planting of a Trojan on the device, which gives access to all the devices, or rather, it can give access to all the device's functions. So it not only allows the monitoring of audio communication, it allows the collection of metadata, the collection of all the information which is on the phone, and probably most alarmingly for most human rights advocates, is that it can also, under certain circumstances, turn the device into a recording device, both video and audio recording. So it's a peculiarly intrusive mechanism or form of surveillance, which obviously greatly affects privacy rights, but also certain other very important human rights, such as freedom of expression and freedom of information. So basically, we have a situation in which the law enforcement and intelligence agencies in our countries say we have to have access to this device because it's the only way to get at these encrypted devices. Whereas privacy advocates say this goes too far, it's too big an intrusion in privacy. Now, the Venice Commission basically draws the conclusion that it must be possible to use this, that there are legitimate arguments for national security bodies in democratic states and law enforcement in democratic states to use computer network exploitation spyware. But because of the potential for privacy intrusions and intrusions in other human rights, it's a mechanism, it's a device which has to be particularly heavily regulated and controlled. So basically a sort of position that would satisfy neither one side nor the other, basically, but that's the position we've taken on it. Now, spyware is a form of targeted surveillance. It's not a bulk interference. There are other very important human rights issues raised by bulk interference, but this is a very targeted interference, and targeted interference has traditionally been very resource intensive. And this is also the case as far as we know in relation to spyware. It's very resource intensive. The figures that everybody quotes are quite old now, but the New York Times came across figures from 2016 indicating that a single such target costs around about $100,000, and that was in 2016. financial terms. So it's a service that you buy, and it's a very expensive service. So that's a factor also in it. The Venice Commission report builds upon the case law of the European Convention, Court of Human Rights, and the case law of the court, as you probably know, has not yet specifically dealt with this issue, but it has dealt more generally with surveillance. However, the Venice Commission report is quite special in that it also engages in a comparative study of European states' laws and practices. And we have looked as closely as we can at these laws and practices and tried to identify best practices. Now, as you know, the Venice Commission is not authorized to start looking at individual states' practices without a request either from the Parliamentary Assembly or the state itself. So we've been careful in this. We haven't identified states that we're not satisfied with. However, you as parliamentary delegations can read between the lines, as it were, in the report and see on the basis of your own knowledge of your own state's practices, do these laws and practices match up to the best practices identified by the Venice Commission? So we see this report that we've done at your request as a means to allow you to engage in a more detailed study of your own state's laws and practices and try to identify deficiencies and gaps that need to be filled. Now, I'll deal with the most important conclusions regarding regulation and control. And to begin with, we make a very simple, but nonetheless very important recommendation that there should be specific legislation governing the use of this tool. Some states simply say this is a mechanism for interception, and they do not regulate it any further. So they don't recognize its special characteristics and its special potential for intrusion and privacy. They simply say it's just a means of getting access to the phone. We don't agree with that. We say that this means is so special that it should be allowed, yes, but it has to be specifically regulated. There has to be a clear legal basis for when it can be used. That is to investigate what types of offences or what types of threats to national security, and these should be set out as precisely as possible. For example, in the Swedish legislation, there's a distinction that's made between the use of spyware to simply monitor telephone conversations, telephone tapping, and the use of spyware to go so far as to turn the device into a listening device. And there's only a very, very limited number of offences for which it's possible to do that. So it's quite specifically stated in the legislation that only for these offences. And in practice, in Sweden, the oversight reports show that it's used hardly ever for that. It's used, as I said, to break encryption. Basically, that's the main function of it, and I think that's the case in other countries too. So the legislation must be clear, but also the authorization that is given to the police or the intelligence bodies to use this tool has to be very specific. It has to state the type of information which is sought. It cannot be a carte blanche to simply say, right, take everything that you want. It has to be as specific and clear as possible. Setting out, obviously not, exactly the information because the investigators can't know that, but nonetheless making it very clear in relation to what threat or what criminal offence, under what circumstances, during which times that information is sought. And this, the more specific the authorization, the easier it is to control the use of this instrument. Now, this instrument also demands a high level of professionalism in the police or intelligence agency using it, because it really requires, for the best type of use of it, requires a layered system within the agency in question, meaning that the people who actually collect the information and filter it are separate from the people doing the investigation of the specific offence or the specific threat to national security. And that second group only get the information that the warrant allows. So the first group do the filtering and cut out all the extraneous information. And then they only give the second group, the investigative group, access to the information which has been set out in the warrant. And that obviously, as I said, requires a high level of professionalism in the body in question, which means, to be quite honest, to be quite frank, that it's really only in democratic rule of law respecting states that we can speak about meaningful safeguards on this mechanism. So there has to be clearly internal rules, internal routines. These have to be backed up by logging requirements so that you know what's going on, and obviously by external oversight. But there has to be also independent authorization in a court or a independent authorization body, applying strict time limits, applying the principle of proportionality, and looking at the circumstances of each particular case. There can be no blanket authorization or automatic authorization. And we know this has been a problem in a number of Council of Europe states, that the court is a simple, in practice, a simple rubber stamp of the application, and that cannot be permitted. So as well as having an independent body that or court that authorizes, has to be some sort of follow-up, and this is the oversight aspect, and that has to be independent too. It has to be sufficiently resourced and funded to be able to be a meaningful oversight, and this applies obviously in general in relation to surveillance, and is particularly acute in another area, that is bulk interference. And here the fact is that there are many Council of Europe states that fall short of what is good best practices here. The safeguards, we regard special safeguards, and I think I have a couple minutes left. I hope I have a couple of minutes left.
You have a few minutes left.
Sorry?
You have a few minutes left, Mr. Cameron.
Yeah,
a few.
Excellent. I'm sorry I'm speaking too quickly. It's my enthusiasm and desire to go through as much of the report as possible. But we regard certain groups as worthy of special protection. In particular, I would raise the issue of journalists here. We know from the Pegasus scandals and other scandals that journalists have been targeted by non-democratic regimes, but even in some democratic regimes. And we therefore consider that particular protections should apply to journalists, but we cannot have an absolute protection of journalists, but we consider that particular protection should apply to journalists and various other categories of people. There should be clear time limits on the use of this. We should have higher standards in relation to the future threat or future crime, and as compared to ongoing crimes or threats in the past. There should be a notification requirement, or in those circumstances where notification is not possible because there can still be ongoing investigations, there should be a standing complaints mechanism to an independent complaints body. There should be destruction requirements of the material, so the material can't just be kept on the basis it might be useful in the future, and that must be very closely linked to the authorization, which was given by the independent court. And finally, there should be states should introduce export controls. Those states which have companies that engage in this type of work must control them quite tightly, because it does create a great potential for violations of human rights. And the problem is, with a company, it's wanting to make a profit, and the risk is that the company will be prepared to sell it to anybody. I'm happy to answer any questions you might have later, but that concludes my presentation.
Thank you very much, Mr. Cameron. And can I then turn to Andreu van den Eynde for his presentation? Thank you very much for being with us. I think if you switch on your microphone.
Okay. Okay. Thank you, Mr. Chairman, esteemed members of the committee. First of all, I would like to express my gratitude to the committee for addressing this critical issue. As you are aware, Spain is among the member states where Citizen Lab and Amnesty International have uncovered a large-scale espionage operation involving Pegasus. This surveillance, reportedly linked to Spanish intelligence agencies, has targeted Catalan politicians, journalists, and human rights activists, notably every Catalan president since 2014, along with their relatives, staff members. The espionage extends to members of the European Parliament that have immunity and even to lawyers like myself. As a criminal lawyer and professor of cybercrime, I have no political affiliations, but I was nonetheless subjected to Pegasus surveillance during the COVID lockdown. At the time, all privileged professional meetings were conducted online. At that time, I was defending the jailed Catalan politicians allegedly responsible for the referendum of independence of Catalonia. I'm fully prepared to respond to any questions or concerns. However, I will begin by addressing the specific obligations placed on Spain in Resolution 2513, particularly paragraph 11.4. First of all, the first key issue concerns the failure of Spanish authorities to provide information on the use of Pegasus, at least to the victims. Despite 5 years having passed since the revelations of the first Catalan victims of espionage, no official Spanish body has provided substantial information about Pegasus. Victims have not been contacted, nor has any public institution acknowledged possession of the spyware. The limited knowledge available stems solely from expert witnesses' reports identifying Pegasus digital traces, investigative journalism, and findings from the PEGA Committee and other international initiatives. Victims have sought information from multiple institutions, including Data Protection Agency, the Spanish Ombudsman, Defensor del Pueblo, various ministries, and the judiciary. However, no authority has yet confirmed possession of Pegasus or disclosed any regulations or protocols governing its use. This brings to the next major concern, which is the abuse of the official secrecy laws. Another critical issue is the misuse of secrecy laws to obstruct access to information, prevent legal recourse, and evade oversight of surveillance activities. Spain continues to rely on a pre-democratic Official Secrets Act to withhold information on Pegasus-related surveillance. This outdated legal framework has been invoked at every stage of legal proceedings to prevent redress for the victims. Representatives of the Spanish National Intelligence Center, the CNI, have systematically cited official secrecy to justify their refusal to disclose information. Despite progress in holding officials accountable, including the indictment of the former CNI director in 3 separate criminal cases for hacking and digital espionage, the government continues to rely on secrecy laws to block transparency. Even the Spanish ombudsman has assumed this argument. Only in the case of former Catalan president Mr. Pere Aragonès did the Spanish Council of Ministers authorize a partial and highly restricted disclosure. This revealed that he had been subjected to Pegasus surveillance for 9 months. The judicial warrants authorizing such surveillance are heavily redacted and lack clear legal justification. In summary, the intelligence services operate without warrants and in some instances with arbitrary and opaque warrants in other cases. To rectify this, Spain must declassify Pegasus related information, reform the Official Secrets Act, and update legislation governing intelligence operators. Finally, I must address the need for effective and timely investigations into the use of Pegasus. Serious obstacles hinder ongoing criminal investigations. In the case of President Aragonés, all relevant evidence has been uncovered solely through the efforts of the victims themselves. While the Barcelona Court of Appeals has issued some positive rulings, most investigative judges continue to obstruct effective inquiries. Despite clear evidence that the same digital infrastructure was used to target multiple victims, courts fail to share information to help other investigations. Spanish judges routinely reject private expert witness reports like the Citizen Lab report and insist that victims' devices should be analyzed again by the police. Then they are forcing us, the victims, to surrender again our private data to the police, which constitutes a secondary victimization. Moreover, courts restrict the scope of investigations to individual acts of hacking, refusing to examine broader patterns involving NSO and CNA activities. International cooperation remains lacking, with Israel failing to collaborate despite being a signatory of the Budapest Convention. Before concluding, I wish to emphasize the accountability of companies that develop and export spyware. My legal case, now led by the strategic litigation team at Iridia, the Barcelona-based Center for Human Rights, has exposed the complex corporate structure of NSO Group subsidiaries in Luxembourg. These entities are deliberately concealed within layers of different companies with frequently changing management. Recently, we got authorization from the Barcelona Court of Appeal to extend legal proceedings against not only NSO, but also to its directors. However, successful prosecution depends on cooperation from Luxembourg to execute multiple European investigation orders. Once again, it's the victims who bear the burden of uncovering information and seeking justice with minimal assistance from Spanish authorities. So in conclusion, the Pegasus scandal in Spain highlights severe violations of fundamental rights and the rule of law. The lack of transparency, misuse of secrecy laws, and systematic obstruction of investigations underscores an urgent need for legal reform. I thus urge this committee to continue monitoring Spain's compliance with human rights regarding mass and targeted surveillance with a specific sensitivity towards the victims. Thank you.
Thank you, Mr. van den Eynde. Could I now invite Mr. Dušan Pokuševski, and I hope I've pronounced that reasonably correctly, to address us. Thank you, Mr. Pokuševski.
Yes, it is hard to pronounce, but you pronounce it correctly. Thank you. Honorable members of the committee, it is both privilege as well as responsibility to be here today to address a grave and urgent matter concerning the ongoing violations of human rights and fundamental freedoms in Serbia. The increasing use of spyware is unfolding alongside a broader decline in democracy and the rule of law. In the recent years, widespread public dissatisfaction has manifested in numerous protests against the government, prompting escalating repression targeting activists, journalists, and civil society members. In Serbia, there have been previous indications of unlawful surveillance and spyware usage, the most recent involving an attempted remote infections of the civil society representatives' phones in late 2023. These incidents fueled suspicions that state authorities may be using Pegasus and other spyware to target activists. On Monday, 16th of December, Amnesty International released a report detailing the widespread illegal use of digital forensic tools and spyware against activists, journalists, and members of civil society in Serbia. Amnesty's forensic analysis revealed that the Ministry of Interior and the Security Information Agency repeatedly detained and questioned citizens, activists, and journalists, during which time their phones were seized and compromised. Authorities unlawfully bypassed device security measures using intrusive but completely legitimate Celebrate digital forensic tools, procured exclusively for national security protection and prosecution of serious crimes. This enabled them to access and extract all data from the phones of the activists and journalists, and in some cases implant on the phones the previously unknown form of spyware, which Amnesty named Novi Spy. This enabled unrestricted access to all contents of the individual's phones and content stored in the cloud, including not only their personal data, but also the personal data of their family members, friends, business associates, acquaintances, and other contacts. Security researchers in Google confirmed Amnesty International's findings. While there were 5 documented cases confirming the use of intrusive tools, Amnesty International conducted interviews with 13 people targeted with spyware or digital forensic searches. Their phones exhibit signs of spyware, leading them to voluntarily seek forensic analysis by international experts. Amnesty technical experts meticulously documented their findings, uncovering clear evidence of device compromise, including the presence of malicious application. Furthermore, the analysis of Novi Spy application revealed an IP address linked to security agency server used to transmit the stolen data from infected phones. Notably, the Serbian government did not comment on the findings of the report, despite receiving the details prior to its publication. Following the report's release, the Security Information Agency dismissed the report as serving the interests of certain agencies and pressure groups. The Ministry of Interior asserted that digital tools are used in accordance with the law. Although it is not possible to determine exactly in how many cases police and security agencies have used spyware for illegal surveillance, Amnesty International is confident that there could have been several hundred of these cases. Google itself sent notification to a significant number of Android phone owners whose phones were compromised and removed malicious software from their devices. This case of illegal use of digital tools have been recorded and documented even after the publication of the Amnesty International report, including against students who have been protesting in Serbia for over 4 months. The use of spyware in Republic of Serbia is not only illegal, but constitutes a criminal offense under provision of the Criminal Code related to unauthorized collection of personal data, computer viruses, and unauthorized access to protected devices and data. Although the Serbian Criminal Procedure Code permits special measures for the surveillance and recording of phone and other communication, the use of spyware falls outside these provisions and cannot be justified, as it grants unrestricted access to all data on a device, not just communication channels. The same applies to the provision of the law on Security Information Agency that regulates the application of special measures. The use of spyware for secret surveillance and communication recording fails to meet the principles of necessity and proportionality, which is essential to any such measures. The European Court of Human Rights has consistently emphasized that surveillance measures must adhere to legal standards, be subject to independent oversight, and be applied only when strictly necessary and proportionate. In addition to the absence of a legal basis for the use of spyware, practice has shown that the protective mechanisms provided by the Constitution and laws are not effective. Authorization of targeted surveillance measures in the framework of criminal proceeding is entrusted to judiciary. None of these actions can be carried out without a prior approval of the court, and it is up to judge who should also assess whether certain measures should be taken at all, and if necessary, whether it is possible to obtain the information using milder measures. The cases listed in Amnesty report, as well as previous cases of targeted surveillance and communication interception, indicate that such court decision is either absent or pro forma without a concrete assessment of the necessity of undertaking surveillance measures in a specific case. Moreover, the independent oversight and monitoring mechanisms for secret surveillance in Serbia, including Ombudsman and Commissioner for the Protection of Personal Data, have traditionally been extremely reluctant to engage in such investigations. Following Amnesty International report, 10 organizations from Serbia focusing on human rights took concrete action to seek accountability for these violations. We filed criminal complaint against unknown perpetrators in the Police and Security Information Agency. We submitted a request to the Ombudsman to initiate an investigation, as well as request to the Commissioner for the Protection of Personal Data to initiate an inspection of the work of the Police and Security Information Agency. As you can see, we exercise all the available mechanisms in Serbia. It is extremely concerning that 3 months after a report revealed evidence of illegal use of spyware, authorities failed to act, allowing these practices to exist and hindering legal outcome. We also sent communication to United Nations Special Rapporteur on the right to privacy and Special Rapporteur on human rights defenders. Last but not least, this case raised another important question that is not exclusively related to Serbia, but rather global, regarding human rights responsibilities of companies and other parties not to sell or transfer equipment and technology that could be easily misused. The Norwegian Ministry of Foreign Affairs, which donated Celebrate UFED technology, and the United Nations Office for Project Service, which managed procurement for the Norwegian government's grant to Serbia Ministry of Interior, failed to conduct an adequate due diligence process to assess and mitigate for the potential risk of this technology to human rights and provide safeguards against its abuse. Significant development took place last week when Celebrate announced that it has suspended the use of its products by relevant customers in Serbia following comprehensive investigation of individual cases documented by Amnesty International. I'm open for any further questions, and thank you for your attention.
Thank you very much. Could I then invite Ms. Milena Berić to address this? Thank you.
Sure. Thank you very much, and thank you for the attention. Dear friends, thank you for the invitation and for the opportunity to speak. My name is Milena Berić, and I will soon turn 43. I have dedicated more than half my life to developing a democratic society in Serbia. As a teenager, I was an activist in the youth movement Otpor, which fought to overthrow Slobodan Milošević in 2000. In 2001, I served as the International Secretary for the Democratic Party during Zoran Đinđić time. I have left Serbia twice. First in 2004 to work and live in Greece, and again in 2011 to Germany. Each time I returned to Belgrade, driven by a sense of obligation to help build a democratic state. I envisioned a place where the rule of law exists, trust in institutions is restored, and human rights are respected. I hoped Serbia would become a full EU member within a few years. Today, I find myself preparing to leave Serbia with my and my husband's 5-year-old daughter, Nora, who has faced numerous developmental challenges since her extremely prematurely birth. Both as a long-time activists, we fear for our personal safety and our ability to speak truth to power. As you're no doubt well aware, students and citizens across Serbia have been protesting en masse, exhausted by the decade-long capture of the state, culminating in a tragic canopy collapse in Novi Sad on November 1st, with 15 innocent lives were lost. Just a month and a half before this tragedy, on Friday, September 12th, around 4 p.m., while employees were at their desks, a group of Russian-speaking hooligans invaded our KROKODIL offices, cutting ties holding the Ukrainian flag, which has been on display since the full-scale Russian invasion began. This intrusion is just one in a series of numerous attacks on our premises and employees that continue unabated, intervened with dozens of slap lawsuits that the state has launched against us and our activists. Police officers appeared very quickly upon receiving my report. I was there, by the way. After a brief conversation, they left without making a record. They did not seem concerned. After all, we have gone through the same procedure dozens of times before. We reported vandalism, violence, and threats. The prosecution, unfortunately, has never reacted. In the mentioned case of the intrusion into KROKODIL offices, I personally sought accountability from the National Security Agency, BIA, Security Information Agency, for your reference. A call followed for me to come in for an informational interview on October 1st last year. I left my jacket and phone outside of the room while I was interviewed, as I did now. After the meeting, when I picked up my personal belongings, I noticed a notification on my phone indicating that my contacts had been exported. I took a screenshot and sent it to the same people who invited me with a simple question: why? In that moment, I realized I was seeking protection and accountability from those backing the perpetrators. I felt as if I was fighting the lost battle. I turned to Amnesty International. 10 days later, their forensics experts confirmed that illegal trafficking software had been placed on my phone during my visit to BIA. 14 days later, they traced the IP address collecting my data directly to the Security Information Agency. I saw my own personal photos and other data in the hands of the state. And for the first time, I was truly afraid for my daughter's safety, for my family, friends, and my colleagues. It felt like I was living in a film where the main character only gets information through whispers and third-hand information. I started leaving my phone turned off in my car during meetings. I wrote messages by hand instead of texting. I knew I was under surveillance, and BIA made sure I knew. Called me in for a meeting every time I spoke with Amnesty International during their forensic investigation. I always went. I always addressed the surveillance issue transparently. Each time they reassured me that such practices did not exist. And each time the investigation into the attack on our offices went nowhere. The calls have not stopped, even today nor yesterday here in Paris. Amnesty International confirmed that my case is not unique. Hundreds of activists, students, journalists, and civil society representatives have faced the same treatment. In December, after 16 years, the KROKODIL Association was forced to downsize. Now, as a fully project-based organization, we spend over 30% of our time dealing with lawsuits, risk management, and public statements, none of which are covered by project funding. Meanwhile, my own salary now covers 2 loans for 2 phones, one infected by novice spyware, and the second one, new one, that I can only hope is secure. Back there, by the way. I believe this situation, the state of an almost surveillance regime, along with last week's police raid on several NGOs to investigate the alleged abuse on USAID funds, is yet another attempt to intimidate civil society organizations. These actions not only delegitimize the work of the civil sector, but also create an atmosphere of fear and uncertainty amid the protests that have gripped Serbia over the past 3 months. In conclusion, I want to remind you that Serbia is a full member of Council of Europe, and I'm really grateful that our members are here behind me. Thank you for being here, Milena and Alexander. And Serbia is also a candidate country for membership in the European Union, and the aforementioned practices are extremely dangerous, not only for building a democratic society in Serbia, but also for the entire Western Balkans region, and for Europe, to which this region undoubtedly belongs. I urge you to respond urgently and support the citizens of Serbia, as well as to protect all of us who are being persecuted and who have been working for decades to develop a better society in our country, because a strong civil society is a fundamental guarantee of a strong and stable democracy. Thank you.
Thank you, Ms. Berić, and thank you to all of our experts. Colleagues, before we proceed to questions from the committee as a whole, I'm going to invite Pieter Omtzigt to address such questions as he wishes to the experts and to address us further. That's because I understand he has to withdraw fairly rapidly. So I hope that you will take this opportunity to further enlighten us upon the progress of your report. Thank you, Pieter.
Yeah. There's 2 things I can do. I can enlighten you a little bit on the progress of my report. Thank you very much for 4, also to Iain, 4 very clear statements. This is not our first hearing. We've seen how this happened to our Polish fellow MP and what impact it had. And it was a similar story to you, Ms. Berić. Spyware is incredibly, but also incredibly invasive in your personal and private life. You can't do a thing. And it's 100 times more invasive than anything George Orwell ever invented in 1984, to which you have to actually present yourself to the screen and tell the screen. And here it is in your pocket, where not noting what's going on. I did mention, Mr. van den Eynde, that we did receive replies from the government. I did not say whether I am fully satisfied with the replies on how the victims have been informed. They seem not to have been informed, and the scandal is still growing. So we've now know that a number of European MPs have been eavesdropped, as well as a number of government leaders. And that's extremely serious. I intend to write a follow-up in April. But I have to say one thing, Mr. Chairman. I do intend to write again to those 4 countries I mentioned: Hungary, Belgium, Israel, and Morocco. If they do not reply, they can expect an invitation from me, and I will ask you to authorize another hearing. If they don't reply, then they have to sit here. And that's not with the victims, but their governments have to tell us why we can't have a discussion with them on what's going on. And then I hope we can have a draft statement for adoption in the committee afterwards. I hope we still have time, because obviously I was absent for a few times. Thank you very much for your statements. And in case we have any questions, we will come back to you.
Thank you, Peter. Can I then go to colleagues who may wish to address questions? First of all, Ms. Castell. Thank you.
Yeah, thank you, Chair, and thank you all the colleagues here, because they have done very clear statements. I would like to talk about or ask about Spain, particularly because the resolution and the recommendation of Mr. Omtzigt's report concluded that Spain should conduct effective, independent, and prompt investigations into all confirmed and alleged cases of spyware abuse, and provide adequate redress to affected victims in cases of unlawful surveillance. Also, similarly, the recommendations of the Venice Commission in the European Parliament included this explicit request. So the obligation to conduct effective, independent, and prompt investigations into all confirmed and alleged cases of spyware misuse, and to provide appropriate redress to victims in cases of unlawful surveillance must also be respected by the Public Prosecutor's Office. Although in Spain, a specialized cybercrime prosecutor's office exists, we've learned from various cases that its role is not to actively defend citizens' rights or promote legal action. So it is concerning that the Public Prosecutor's Office is not fulfilling its mission of promoting the action of justice, to clarify the actions of the intelligence services to their ultimate consequences. So my question is to Mr. Van den Eynde, but also for the Serbian colleagues too. Could you explain the role of the public prosecutor in your case, or in the cases you are leading as a legal representative? Thank you very much.
Okay, thank you. Well, regarding Spain, we have to specify that, of course, there's a specialized cybercrime prosecutor in Spain, at least in Barcelona, which is dealing with all, the dozens of cases that we have. So he's not like just a current prosecutor. He's a specialized one. So he is really aware of what spyware means. And we as the victims, and I know several cases because I'm representing other victims and I'm a victim myself, we've seen that he's opposing all investigation measures that we are proposing. He has opposed to the very essence of jurisdiction in Spain, saying Spain has no jurisdiction because we don't know where the perpetrator of the offense is, which is a nonsense when we speak about cybercrime. But anyway, he's opposing charges to the allegedly authors. He's opposing the joinder of all the proceedings, so we can learn from the information of other criminal proceedings, and they are all separated. And he's opposing that we can retrieve information, technical information from one case to another. He's opposing the validity of the expert witnesses report from Citizen Lab and Amnesty International. And, you know, the only positive thing is that we are winning all these discussions in the Court of Appeals, because in the end, we are discussing about digital information. So even though you are a prosecutor, a Spanish prosecutor, you cannot convince us that a digital trace of a software in a phone is there. So my phone has been hacked. And all the hypotheses about, you know, people from strange organizations that could be the perpetrators of something that we know is only in hands of the CNI, it's a nonsense. Anyway, so the prosecutor is not in the side of the victims. We've managed to win all the fights we have had, at least in the Court of Appeals. But we really hope that sometimes he can align with us and promote justice. That's my opinion.
Thank you. Before coming to other experts, could I ask Iain Cameron if he's anything to add in light of the observations from Ms. Castell?
Thank you, Chair. Yes, I think both the Serbian and the Spanish examples show very, very clearly the abuse part of the problem, and bearing in mind how serious these abuses are, one can, of course, pose the question: well, is spyware ever justified when we see this level of abuse? And I would stress that one of the problems that is built in to the sale of this service, because you don't sell the software, you sell it as a service, is this commercial aspect that the NSO company appears to be willing to sell it to anybody and under a commercial logic. By that I mean, you know, they have sold it on the basis that this will give you access to everything. They have not sold it. We will restrict the information in order to protect privacy. I seem to be disconnected.
We can hear you, so do finish. There we go. Please continue. We may be able to come back to it. No.
Back again now, so
I'll be very.
I don't think it was a deliberate interference.
I think you're proving the efficacy of the Pegasus software, but carry on here.
Yes, quod erat demonstratum. Yes, yes. What I was saying was that this is the dangers of having this commercial logic. It's been sold as a commercial tool. It's been sold as a sort of get one, you know, buy one get five for free type of. I'm not being, you know, facetious here. I'm meaning that there is that danger to it, that the company wants to make a profit and will sell it to anybody, and that has made it, of course, even more difficult to get at the truth of the matter, because there is also business secrecy involved. The company does not want to reveal its capabilities and exactly how the tool works. So and which, in particular, which apps have been attacked in order to get at the information. But it's also a part that has been taken up by Peter and others, that changed social habits mean that we carry so much intimate information in our telephones nowadays. It means that getting access to the telephone gives you so much information about the person in question. And it would be a sad state of affairs if we had to start restricting this information. But unfortunately, this is now the case for human rights activists in many countries, that they should have two phones, as we heard from from Serbia. But I would nonetheless stress that it's important to remember that there can be legitimate uses of this. The trouble is that these legitimate uses only really work properly in those countries which take human rights seriously and take the rule of law seriously. So it is a tool which has a huge potential for abuse. That's very, very clear. And the Venice Commission report attempts to find under what circumstances the tool could nonetheless be justified. But we make it very clear that the controls have to be strong. Thank you.
Thank you. Before coming back to colleagues, could I also ask Ms. Berić and Mr. Pokuševski if they would like to add anything to these comments? Thank you.
I assume that it was also the question for the Serbia. Yes. Regarding the role of the prosecutor, we also have the Office of the Prosecutor for Cybercrime. Since we don't have case law regarding the spyware in Serbia, I think this is in a way the first case that we are expecting some type of outcome. As you saw from my speech, we try to initiate every mechanism that is available. And we are really expecting from the institutions to give their reactions and to prosecute the people that are the perpetrators of these deeds, if I can say it like that. We submitted the criminal complaint. It was at the end of December. The information that we have so far is that there is the formed case within the prosecutor office, but we don't have any further information if certainly the investigation did not start yet. So we are waiting for the institution to initiate everything that is within their competencies and jurisdictions. So I cannot give you more follow-up on this case, but as we know, the case is formed within the prosecutor office. And also, on the other hand, regarding the mechanism within the ombudsperson and the investigation that ombudsperson can conduct, we submitted our allegation to the ombudsperson as well. Then he replied to us that the victim should submit official complaint for the individual case. There was one victim willing to submit that type of complaint, and and the ombudsman informed us that he received the complaint and that he will react upon this. So I cannot give you more information, but we are really expecting from the institutions to be thorough in this subject.
Thank you. Ms. Berić, is there anything you would wish to add at this stage? No. Thank you. Could I invite Mr. Pablo Hispan to...
Thank you very much, Mr. Chairman. First of all, it's incredible that in the middle of a debate of such character and such importance, the rapporteur left the hearing. So it's because he's not going to listen our concerns and our questions. So I think that, as happened with this report, the conclusions are already written. So, and that's the reason that the reporter doesn't listen to all the members of the committee.
I am concerned that Mr. Omtzigt had to leave when he did. Yes. However, you may rest assured that he will be fully advised as to the further part of these proceedings, the questions raised and the responses that are made. And I will ensure that that happens. Thank you, Pablo. Do you want to continue?
Thank you. Yes. Thank you, Mr. Chairman. I wanted to say only three things. First of all, last week there was a decision of the European Court of Human Rights about the coup d'etat against the Spanish constitutional order that condemn again and underline the condemn of the Spanish court against those politicians that disobey the Spanish laws. So this question is already at the courts, and the European Court of Human Rights has give the agreement with the Spanish court. The second issue is that we are, in the case of Mr. Van den Eynde, we are talking about a case that is at the courts. There are some courts in Spain that are looking for that. And in Spain, there is not a monopoly general prosecutor. Also, the public people can prosecute. It's a special legal system, so there is not a monopoly of the general prosecutor. So there is no problem that if some prosecutor act or not act, because there for the public opinion there are more tools. And as I say, there are a lot of courts that are investigation that issue, and also the Secret Service has said that they have used this spyware, that it was always under the control of the Supreme Court and following the Venice Commission report. So there is no case about that. There is no case, and if there is a case, there are courts, and in the courts are looking for that. And I say that. It is the last issue is about that in the case of Mr. Van der Eynde, that he is also a close person to Esquerra Republicana, because he is lawyer of one of the politician. It was in 2020, okay? It was under the socialist government, and with what it is a joke, a very big joke, that the party that is supporting the government is saying that the government is spying them. So this is an incredible joke against the Spanish rule of law, but they must explain why. If this is extremely grave issue, why they are supporting the government. Thank you, Mr. Chairman.
Thank you, Pablo. I noticed there was no question mark at the end of that statement, so we'll move on. Mr. Lamu, I believe you would like to raise a question. Thank you.
Thank you, Mr. Chair. Thank you, Mr. Hispan, always for his measured words and interventions. As the President of Catalonia, Salvador Illa, has repeatedly stated, in this case, we understand the feelings of those who have been affected with Pegasus use, such as Mr. Andreu Van der Eynde, for example. Therefore, we also understand the vehemence with which he defends his case. And I want to make clear the respect with which I make my intervention. That is why the parties in the Congress agreed to establish in Spain a commission of inquiry on that matter, that it's still open in our Congress for the investigation thoroughly of this subject. Also, the Socialist Party has stated and maintains that any judicial or police action must comply with what the law provides and what the law authorizes. And if that has not been the case, the issue must be thoroughly investigated, so all the parts involved, as Mr. Van der Eynde has said prior, can demand what they believe to be their right. We must remember also, and no one has stated here still, that the President Sanchez himself and other members of the Spanish government were also spied with Pegasus in the meantime. In our country, the rule of law is respected, but the abusive or arbitrary use of such tools is not. The law prohibits the judges consequently investigated and prosecuted. Therefore, let me be clear, anyone who uses these tools illegally in Spain will be investigated, prosecuted, and at last convicted. And I want to make one question to Mr. Van der Eynde. Which do you think would be the outcome of today's news on Audiencia Barcelona and the executives of NSO enterprises investigated, and what it would explain to us, not only about the cases that we had in Spain, but all the cases involved in the espionage via Pegasus. Thank you very much.
Thank you. It's always helpful when members of the Parliamentary Assembly rise above national and domestic political disputes in order to address these issues. So I'm obliged to all my colleagues from Spain.
Thank you, Mr. Chairman. I think there are three interesting topics. I'm addressing it without any specific order. No, the problem is not that the victims cannot demand explanations. We can do that. we want to get explanations. We are asking the ombudsman. He says, I cannot speak. We are asking data protection agency. They say, we cannot speak, secret. We are asking all the committees that control the expenditure. They say, we cannot speak. We ask the CNI and they say, we cannot speak. So we are demanding explanations, but we are not getting explanations. So that's the problem. So of course we have the rights. The problem is we want solutions, not only, it's not something that we do as a hobby. We are victims. We want to know where our data is. And they have our data in a file, in a closet, in a building near Madrid with my name on it. Why is that they don't provide us this information? So that would be my first question. Of course, NSO has to be liable because it's in our criminal code. You cannot sell spyware if it's used illegally. And of course, there's a law that says, okay, you can make a remote search of a phone. So it's in our procedural law. But the problem is that we don't know a single case where Pegasus has been used for investigating a crime. We don't know any single case. We know thousands of cases where they used Pegasus to spy on journalists, human rights activists, but we don't know how are they using this for law enforcement. So that's what we are asking for. And then the most important thing for the end, it's so important the information that the member has said about CNI assuming they have Pegasus, because I know all the cases, I know all the information, and I have never seen the CNI assuming they use Pegasus. I haven't seen it. So it's a relevant information that you should submit to the prosecutor, because I haven't seen an official statement about that. They say they have spied on one people. We know they have spied on dozens of people, but they said 18. We don't know the names, but we have analyzed more than 100 of phones. They have Pegasus, but the CNI has never assumed having the product Pegasus. So if you have any clue about that, it's so important that you provide it to the authorities.
Thank you. Ms. Pančić-Pilja, thank you.
Thank you, President. It's a little bit awkward to speak about this. We don't have a rapporteur, but okay. I don't have question. I have a statement because our guest spoke about Serbia and situation in Serbia, and said something about Novi Sad and tragedy in Novi Sad. I am from Novi Sad, and there was very big tragedy happened there. But that tragedy is being used for political purpose. And you know, Serbia is a very democratic country where you have people on the street blocking traffic and hitting police. And the police do not use force like in some Europe.
Can I come in, Ms. Pančić-Pilja? The purpose of examining 4 experts is in relation to Pegasus.
Yes, I know, but they said something about that, and then I need really to speak about that topic.
No, the fact that someone may incidentally have alluded to an issue does not mean that it's relevant to the examination of the 4 experts that we have today.
Yes, but experts said something about that. If you listen carefully.
I did listen carefully, I can assure you.
Yes, but they said something about Novi Sad and protests and people on the street.
We're not here to indulge in domestic political disputes. Thank you.
Thank you. Okay. And second, Security and Law Enforcement Agency of the Republic of Serbia operates strictly in according with the Constitution and laws, particularly the Criminal Procedure Code, which clearly defines the condition and procedure for obtained evidence. Any application of special investigative measures, including electronic communications, surveillance, is only possible with a court order and within strictly legal boundaries. Claims of illegal surveillance are false and malicious, and we need to wait prosecutor. All activities of state institution are subject to democratic and judicial oversight, and any insinuation to the contrary are an attempt to undermine their credibility. Serbia remains committed to protecting the rights and freedoms of all its citizens, and we firmly reject any attempt to discredit its institution. I repeat, we need to wait prosecutor. Everything else is rumors without evidence. Thank you.
Could I invite Mr. Vardanian to, if he has a question, he could ask it,
just
but
a
if he has a
comment and-
statement, he can make it.
No, I have a general remark if in the absence of reporter for sure. I'm afraid that our legislation in general, even the current amendments and current conventional approaches towards the regulation of the issue with the spyware are still outdated. And I'm not sure that it would be possible to find any kind of sustainable solution without the will of telecommunication, not only the state, but telecommunications, civil society, and first of all, those who are engaged in technologies to change. Because what we are saying, we are speaking about legal regulation of something which is developing much faster than law. And we may use not only state channels, but also any other channels to actually use this spyware against this or that person. So I do believe that this discussion is quite interesting, but I don't believe that we would be able to find a solution if we wouldn't be engaged the industry and those who are rather responsible for the development of this issue, because states are frankly speaking, the states represented here in the problems discussing here not are the worst examples of the using of the spyware worldwide, because we have much interesting cases. And I would like just to say that maybe a little bit deviating from the discussion, I would like just to say that we should more concentrate on the finding the technical solution, how it is possible to not allowing this usage. Otherwise, we will have outdated legislation every day, because technologies are developing much quicker in comparison with the law, and especially in comparison with the international fora.
Thank you. Could I invite Iain Cameron to respond to that observation from Mr. Vardanian from the relatively neutral standpoint of the Venice Commission? Thank you.
Thank you, and I'm delighted to be described as relatively neutral. My colleague on the Parliamentary Assembly, also in the Venice Commission, definitely has a point that there is a close link here between state capacity and the capacity of private companies, and this is it's not unusual, we find, as far as I can see, that states have been buying this capacity because they lack it themselves. So there is this aspect that even states with a highly developed competence in the area of electronic surveillance have been buying this capacity from other companies. And normally, one would say that in a fast changing technological field, then it's important to have neutral legislation, that is, general legislation which allows new technologies to come in. So you don't sort of attempt to freeze everything in the legislation. And this is correct. However, this specific tool causes so many problems for privacy in particular, but even certain other human rights, that one of our primary recommendations is that the tool should be legislated in specific provisions. We would also advise having a sunset clause in such legislation in order to give the national parliament the opportunity to look back at how the legislation was used, because the argument is always made that we must have this legislation, but providing for it specifically and for a specific test period is a very useful mechanism, because it allows the national parliament to have a commission of inquiry, to look at as much information as can be given to it, because some of it has to be kept secret, but to look at the information that can be given to it, to evaluate it, to see which concrete steps can be taken. But I agree that, and as I said earlier, these allegations that we've heard, well-founded allegations, I should say, of abuse in many countries, indicate that there should be a renewed emphasis, I would say, in this committee on these issues of independence of courts, on these issues of effective oversight. And effective oversight in this area means having an independent oversight body that is sufficiently competent and sufficiently well funded to act as a proper safeguard, because only in such circumstances can we say that the public will be reassured that this tool is not being abused. So I think this committee should have a renewed focus. It has many things to look at, I regret to say, but it could have a renewed focus on the independence of courts and the effectiveness of oversight in this field.
Thank you. I think, Mr. Atherton, you wanted to perhaps ask a question or contribute more widely to the debate. Thank you.
A comment, a revelation, and a question. First of all, we have to say that we are dealing with one of the most immoral things in our societies. Evading someone's communication is, for me, is something which is unacceptable. It's a critical issue, for sure. And listening to Mr. Cameron, to Mr. Van der Leyen, the main problem is the tracing, the problem in tracing the surveillance. I'm coming from Cyprus. We have, everybody knows in Cyprus that everybody can be surveyed. I have informal inside information with close friends that even my telephone is under surveillance, illegal surveillance. I can't prove it. Even if I go to the police station, the police is one part of the surveillance system. So the main problem is how can we trace the surveillance? And this is the main, when I listen to Mr. Cameron about the denial of the authorities that they do act in such a manner, or you, I mean, constantly denied accession or disclosure of information. So the problem is, how do we proceed when the authorities are not willing, they're not eager, and they are not obliged, clearly, to obey some rules, basic rules? How can I prove that my telephone is not is either surveilled or is not? This is one major. This is a question, and finally, there is another question. Can we at least create a mechanism with experts in European level, at least, not in national, because I don't trust national independent bodies, because everybody seeks for another renewal of his position, so they do whatever the governments tell them to do. So can we, or do we have the means of creating an agency, international agency, of providing legal expert expertise or forensic expertise, or obliging the national authorities to give concrete answers when whether there is surveillance or not. Otherwise, we're going to discuss our experiences here and there when the problem is going to be magnified all the time.
I think we did hear evidence that, for example, Amnesty International have access to technology to identify if an individual phone has been infected by Pegasus software, for example. I think it may be Ms. Berić who mentioned that, but would you like to comment?
Yeah, sure. It's very simple. When I got in for the interview and I got out, my phone showed me information that my contacts has been exported, right? And it's very simple. You can see it with your own eyes. And when I immediately, I didn't address that to Amnesty International. I addressed that to exactly people who did it. And they didn't say, no, it hasn't happened. It came afterwards, as you can tell. They said, but that is a procedure when you come into the Secret Service office. They say, if that is a procedure, will come with the lawyer, and then you will explain, because here is the proof. I was in front of the building where did that happen. So when you talk about the mechanisms, sometimes it's very, very clear. Your phone shows that to you. And further forensics shows exactly the time and the method how that has happened, further forensics. So to your question, you can, many times you can see it by that is just from my experience, yeah.
Well, of course, it's always a problem proof. We're going to draw to a close soon, but first of all, Ms. Jordanova, I believe you had a question.
Yes, thank you, Mr. Chairman. I have a question actually, and it is, could I ask Mr. Cameron to elaborate a little bit more about one of the recommendations made by the Venice Commission, and I think that it is directly connected with our hearing today. The Venice Commission is recommending that the person under surveillance must be notified subsequently. It is one of the guarantees for this person to monitor the following steps and to ensure protection of his or her human rights. But in this recommendation and in your discussions, how could you divide the two separate cases? Because we have a case where the person can be under surveillance in compliance with the law. And there are cases when the person is under surveillance illegally. And obviously we should approach those two different cases, types of cases differently. So what are your deliberation, the matter, recommendation, and obviously following the discussion, when the person is under surveillance illegally, the lack of proof, the lack of information is obviously a big problem as well.
Thank you. Mr. Cameron, could you respond to that quite shortly? Thank you.
First of all, as we heard previously, the good thing, the good news, is that the use of such spyware almost always leaves a trace, a digital trace. There's also certain self-defense measures that you can take, just as the owner of the phone, to delete certain apps. Certain apps are particularly vulnerable to exploitation. Other apps are not. Newer models of phones. I'm not trying to, do a sales pitch for the newest model of the phone, but newer models are more generally much more difficult to exploit than older models, and so on. So there are certain things you can do yourself, and as we heard, Amnesty International or other such bodies can check your phone for you and can, help in this respect. That deals with the illegal monitoring. With the legal monitoring, as you say, there is a difficulty because notification systems always have to have exceptions to them. They always have to say, if the investigation is ongoing, you cannot be notified. If you have an organized crime investigation, you can't, notify the people who have been targeted, because that tips them off to the entire investigation. So you need to have exceptions to this. And in relation to national security threats tend to be extremely long-lasting. So if the Russians or somebody else are tapping you, surveying you, that's going to be forever, basically, or for a long time. So that there have to be exceptions to notification requirements. What you can do, and here I would lift both Belgium and the Netherlands as good examples here, their oversight bodies have looked at these issues and attempted to give information, as much information as they can, to the public on under what circumstances are the complaints that we have received as an oversight body would have been justified. By that I mean they separate the complaints into complaints that have a basis in genuinely, and complaints that are spurious or people are paranoid. So the practice of these oversight bodies has been quite useful in this respect, that you can give aggregate figures showing under what circumstances notification has not been made. You can also provide a requirement in the law that any time you do not notify, you must seek the permission of the oversight body, or at least notify the oversight body, so that the oversight body can go into that particular issue. So there are ways of making it work.
Thank you. Finally, Mr. Bosic, I believe you wanted to say something. Thank you.
Thank you, Chair. Surveillance systems will always be misused and abused, and always were. Even when we had wired phones, they were misused by the states and governments and intelligence services. So it's very, very hard to believe that governments and intelligence services will not continue to do that. The question is how to oppose that. So the big technological companies like Meta, like Google, like other companies may help in that sense. Maybe legislation should be adopted to motivate them to fight that kind of surveillance, because these spywares are using their products to get into your phones. And they are selling you the products claiming that they are secure. They are not. So they have means to fight that much better than we can do that by our declarations and adoptions of some documents. Thank you.
Thank you. Could I thank our four experts for their contributions, which have been extremely useful. Could I thank colleagues for their contributions, which have been in relative terms useful. And could I say that the Secretariat will keep the Rapporteur fully informed with respect to what he may have missed. But for the moment, again, I extend my thanks to our four experts, including Mr. Cameron online, and we will now proceed with the other business and go offline for that purpose. Thank you again. I believe Ms. Saville, you attended the public hearing, which of course you're entitled to do, but if you could now withdraw. Thank you.